This module focused on one of the most critical areas of real estate compliance: compensation and financial disclosure. Arizona real estate law requires complete transparency regarding how, when, and from whom a licensee receives compensation, as well as full disclosure of any personal or financial interest a licensee may hold in a transaction. These laws are designed to maintain fairness, ensure accountability, and protect the integrity of all real estate dealings. Under ARS, paragraph 32-2155A, a real estate licensee may only receive compensation for licensed activities from their employing broker. This means that all payments, whether they are commissions, referral fees, bonuses, or gifts, must be made to and through the broker, never directly to the agent. The law reinforces the broker's supervisory responsibility and ensures accurate accounting, taxation, and record keeping. For example, if a builder or lender offers a salesperson a cash incentive, that payment must be disclosed and directed through the brokerage to maintain compliance. It is also unlawful for a licensee to accept compensation from multiple parties to the same transaction without prior written consent from all parties involved, as required by Commissioner's Rule R428-1101F. This prevents conflicts of interest and ensures all parties are fully informed about the licensee's financial relationships. Similarly, ARS, paragraph 32-153A, 10, authorizes disciplinary action for accepting unapproved compensation or sharing commissions improperly. Every payment must be authorized by the broker and recorded in the brokerage's files in accordance with ARS, paragraph 32-215101D. The module also explored the duty to disclose present or prospective interest in a real estate transaction. Under ARS, paragraph 32-2153A, 3, and Commissioner's Rule R428-1101E, a licensee must provide written disclosure when they, a family member, or a business entity they are affiliated with has or may acquire an ownership or financial interest in the property. This includes acting as a principal, representing a family-owned property, or having a future investment stake. The disclosure must be made before entering into any agreement or contract. A common example is when a licensee decides to purchase a property for themselves. In this case, they must disclose in writing that they are a licensed real estate professional acting as a buyer before submitting an offer. Likewise, if a licensee intends to sell a property they own or co-own, that ownership must be clearly disclosed in all advertising, contracts, and listing materials. Failure to make these disclosures could result in disciplinary action or claims of misrepresentation. The disclosure of prospective interests, such as expected profits, partnership shares, or referral benefits, is equally important. Arizona courts, such as in Hoffman versus Greenberg, 1972, have held that failing to disclose an anticipated benefit constitutes constructive fraud. Even if the benefit is not yet realized, the licensee's duty to act honestly requires disclosure so that clients and other parties can make fully informed decisions. It is best to have the client order their own reports and not use someone else's reports from a previous transaction. This requirement also extends to affiliated business arrangements, AFBAs, and marketing service agreements, MSAs, which must comply with both Arizona law and RESBA Section 8C. 4. For instance, if a broker owns a partial interest in a title company or mortgage firm, the broker must use an affiliated business arrangement disclosure statement to inform clients of the relationship and their right to choose any service provider. Ultimately, this module emphasized that honesty and transparency are not only professional expectations, they are legal obligations. Accepting compensation or maintaining interests without full disclosure undermines the trust that forms the foundation of every real estate transaction. Key takeaways: all compensation must go through the employing broker as required by ARS, paragraph 32-2155A. Written consent is required before accepting payment from multiple parties to the same transaction. Licensees must disclose any ownership, family, or financial interest in a property or transaction before entering into an agreement. Prospective interests and referral benefits must also be disclosed, even if not yet realized. It would be material knowledge of the owner. However, the buyer should beware and look to gain reports of their own. Failure to disclose or accept compensation improperly can result in severe disciplinary action